Okay, this is Mike Benoit, and now I'm talking regarding my motion for summary judgment on the case where the IRS and the district court stole my home from me, 300,000 or so in equity, and I had a little situation when the $2,000 that they handed to me at the end of this fiasco. Today I went in to cash that $2,000. Out of a $300,000 equity, and I got a ration at the bank about the check and I've been banking there for years, and the check looked a little different, et cetera, et cetera. And talk about a guy boiling over with all this stress. This is years of stress with these tyrants. But anyway, keep in mind that, maybe you're watching this and you think, oh, the guy didn't pay his taxes, he should pay his taxes, da, da, da. Well, keep in mind that this is a fight for a jury trial. Don't convict me of murder until I have my trial. And so anyway, but I'm not going to get a jury trial. They're just going to steal my house. And this is the documentation of this tyranny. Hopefully someday somebody will get some benefit out of this. That's why I'm doing it, because I can't stand this thing, but I want some sort of documentation on this. But anyway, in my motion for summary judgment, I list the statement of facts, and I supply affidavits to back up the statement of facts and letters that are evidentiary letters or evidentiary forms that back up these statements of facts. And by the way, I submit these things under the penalty of perjury on firsthand knowledge and not information and belief. That's not acceptable under this kind of thing that the United States government got away with. So fact one, September 5th, 1996, defendant Benoit replied to a form letter from the IRS asking for a tax return, stating that he was not a taxpayer or an individual that's required to file a tax. And that, a taxpayer in the Internal Revenue Code is someone who's subject to or liable for a tax. That's a one-word term, and it's defined in the Internal Revenue Code. So if you're, let's say, you're 20 years old and you never, got any income, if you will, you're not a taxpayer because you're not subject to or liable for an Internal Revenue Code. So if you don't have any income, taxable income, and there's nothing in the code that makes you liable, then you're not a taxpayer. And so that's what I'm telling them here. In this letter, I stated that until they could prove otherwise, I was not a taxpayer or an individual that's required to file a return. So then my Exhibit 1 backs that up, but it basically says that if they don't reply and prove otherwise, they're acquiescent to my conditions, my statement. This is in 1996. So I never received an answer to that, and there's no record of having any reply having been sent out. They just ignore you. Numerous occasions prior to my proposed assessment or notice of deficiencies for the alleged liabilities of this action, I wrote letters to the IRS denying owing taxes, being a taxpayer, and repeatedly request the IRS send documentation to the contrary if they held contrary views. None ever came. On number 4 here, on September 30th, 1997, an agent blank blank, they'll probably put me in prison when I say her name, sent a letter to me with an examination report for 95 and 96. I attached that exhibit. And October 15th, same year, I wrote a reply to her denying owing any money or being subject to any tax, and asking for her to forward the code section of the Internal Revenue Code that she claims made me liable for a tax. That letter was never answered. I mean, a little letter, something, May 29, 1998, a notice of deficiency was sent to me, signed by this other person. I got that exhibit in there. June 3rd, I replied to that. You see, I'm replying to all this stuff. Defendant replied to her, denying being a person responsible for any tax. and I asked for the code section. The letter closed with, if I don't hear from you in 30 days, then, well, your lack of response will establish the presumption that neither you nor those in your service has the documentation to make or support any presumption that I'm one who comes in within the purview of your statutory authority, whereby you can make any claim of requirement or obligation on me. The letter was never answered. Maybe this will be too boring to keep and read all of these, but what the heck, let's do it. All right, we'll do it quick. November 23rd, 1998, the IRS generated forms captioned, "We changed your account." Of course, I responded and asked for, I responded through counsel seeking documents regarding these years, specifically a certified copy of a valid assessment, 1999. We never got it. On December 15th, I wrote to IRS agent M such and such, stating that he was still waiting to be shown where he was made liable. This third-party stuff. No answer to that one. Periodically, at the end of the year, starting in 2/1 through 4, the defendant would receive form notices asking for money due. I would reply denying owing any money. Then on 2005, the new agents jump in, and I deny owing any money, and I'm asking for the code section again. Finally, the first form 4340, and legally that's an important form, and the failure to give that form until March 29, 2007, would be enough to refute or rebut the presumption given to the form that it was correct and accurate, and should allow me to proceed to trial in front of a jury. And again, this outlandish amount of money that they said I owed, $144,000. Maybe they could prove a case where I proved that I owe $20,000. But if you resist these tyrants, they're going to make you pay, and make you pay big time. So maybe you're saying to yourself, yeah, he should have paid his taxes. Well, if they make a wild claim that I owe $144,000, would you pay that? So by letter of 2008, stated that Christy Hardy, through my FOIA request on these things, trying to get information from these guys was another nightmare story. It'd take 3 hours of video to explain that, to try to get information from them. But their agent, Christy Hardy, disclosure specialist, stated that substitutes for returns were destroyed. So as if they had them. They're not, making that statement makes it appear they had them, but so substitutes for returns would be important information as to the beginning of a liability, but they say they were destroyed, so they don't have them. And it would be prima facie evidence that they would need. And then a more important fact is that the IRS had never sent any notice to me that they had assessed taxes regarding me, my property, or any activity. Now, because the Franchise Tax Board is listed as the defendant in this case, and this is a real bizarre way just to bring them in as an additional plaintiff, but so it's like their particular so-called lien has to be adjudicated as well, and you'll see that in this process it never gets adjudicated. It's just valid. It's just stamped as valid without any sense of adjudication of the validity of the lien. It's just assumed valid. And this thing is riddled with so much tyranny, it's unbelievable. But they sent, the Franchise Tax Board sent a final notice for tax years 96 on 7/30/98. Now keep in mind they get their information from the IRS. So if you wonder why they had some. On September 8, 1998, a person using the name of such and such issued a delinquency letter. Defendant wrote back, enclosing the previous letter, trying to get some more answers. And this person stated paying this amount. Defendant wrote back, denying owing any amount. The FTB sends another form out, notice of proposed assessment, which means there's no assessment at the time. And the FTB sends for 95 and 96 a notice of state income tax due. But there's a 3-month period there where I replied to their form of proposed assessment, denying any taxes. And in my argument here, you'll find out why that's important. And then they send a final notice on such and such a date. Then the Franchise Tax Board issues forms titled Tax Lien Notice. Okay? And then the Franchise Tax Board sent defendant a form titled Income Tax Amnesty Application, to which I answered with a flat denial of owing any money. All right, so then I list the standard of review for a summary judgment and the legal standards that are set up for a summary judgment. And the court cases that get involved there, which basically means there has to be no material issue, no issue of material fact for the judge to grant a summary judgment, meaning there's no facts in dispute. If anybody looks at any of this, they have to know that you can't deny that there's lots of facts in dispute. But this is the way they can circumvent the Constitution and our right of trial by jury. So now my argument was that all federal taxes are imposed by specific code sections of the Internal Revenue Code, and that what the definition of a taxpayer is, I imposed the tax code sections for that, and the assessment authority, and where that's granted, and that's under 6201 of the Internal Revenue Code, and then the method of assessment. 6203. Now, I've denied being liable for any return for revenue code tax for those years at every notice or every communique from the Internal Revenue Notice. I denied being liable for any tax, and I've asked for proof that I imposed the tax. Nothing even remotely answering these requests were ever sent to me. The IRS Code and the Code of Federal Regulations requires that upon request, the taxpayer be sent the pertinent parts of the assessment. And I never got anything. And the Code of Federal Regulations goes into that as well. And it says if the taxpayer requests a copy of the record of assessment, he shall be furnished with a copy of the pertinent parts of the assessment, which shall set forth the name of the taxpayer, the date of the assessment, the character of the liability assessed, the taxable period, and the amounts assessed. Again, per their own code, I didn't get that. The Internal Revenue Service has never produced a record of assessment as specified in the Huff case. The court stated that the record contains no evidence that the Huffs received copies of their assessments pursuant to their request under 6203, same as mine. We conclude there are genuine issues as to whether the IRS complied with requirement 6203. So without an assessment, there's no liability. Request for these assessments plus the answers or lack of answers constitutes an offer of proof that they do not exist. The courts have ruled that when no presentation of evidence to the contrary, a Form 4340 is some presumptive proof for that assessments was made. And we agree with the other courts. 4340 can be presumptive proof of a valid assessment where the taxpayer has produced no evidence to counter that presumption. Now, anybody anywhere could look at this and say I didn't produce any evidence that counters the presumption of a form that was first issued in 2007, wasn't furnished according to my request from 96 through up to 2007, that their presumption has been rebutted. And let's go for a trial. Let's have our trial. I relied on the knowledge that they didn't respond. That there was a law that imposed a tax on me, and they didn't produce any assessment. I was not a taxpayer as defined in the code. So the Internal Revenue Code calls for specific methods to do their assessment. I didn't argue, and if you and I are going in and we have a case, there's a doctrine of laches, which means that doctrine doesn't apply to the district court. That means you could be time barred if you don't present your thing on a reasonable time frame. Now here I'm thinking, okay, I got enough stuff here to show not only in my response to the government's motion for summary judgment, but in my motion for summary judgment, there's enough here to say, hey, come on, he's produced enough evidence to rebut the presumption of this Form 4340, and that the IRS didn't comply with the regulations, and that, hey, this guy should have a trial. And it kind of, I guess, it's something that doesn't matter much to the government, and it was interesting for me to find out, that they filed this suit something like 3 or 4 days or within a week of statute of limitations running out. And even though, the statute of limitation used to be 6 months. Now, you would think that if somebody, that it would be only the righteous thing to do if someone said, I don't owe you any money, government. And for the government to say, well, this guy says he doesn't owe any money. He does owe money. Let's take him to court. Now, let's handle this dispute. I'm sitting there thinking, well, they're not answering the question, so they can't. So, they're acquiescing, and they're not going to bother me. Well, they filed this suit, and they do it, like 10 years later. And you think, geez, what purpose? Penalties and interest and everything else to steal somebody's home? But anyway, if you look back at the history of the legislation, it used to be a 6-year period. And the congressional record from the Senate, Mr. Lieberman, this is Mr. Lieberman who proposed this legislation and changed it from 6 years to 10 years. He says, I thank the senator from New York for allowing me to proceed in this way. I rise to indicate to my colleagues that I have introduced legislation I'm proud to say is co-sponsored at this point by Senators Glenn, Levin, Akaka, Cole, and Dodd that would extend the Internal Revenue Service statute of limitation on collecting taxes. That sounds like a pretty dry, arcane, and technical subject, Mr. President, but the intent of the bill, which is Senate Bill 3165, is to enable the Internal Revenue Service to collect literally hundreds of millions of dollars in taxes that are owed to the government but have not been paid. These are not taxes that are part of the so-called underground or hidden economy. These are taxes that the taxpayer knows he or she owes, and the government knows he or she owes, but simply have not been collected. In fairness to all the honest tax-paying citizens of this country, we must not let our rights to collect these overdue taxes slip through our fingers. And I think Lieberman's probably a lawyer. I can't swear to that. But the understanding is that this was given more time to collect taxes that everybody agreed was owed. They don't need 10 years to collect taxes. If someone says, I don't know this. As soon as they hear that, shouldn't they be saying, let's start enforcement collection action. Let's go to the United States District Court, prove up that he owes these, and get the money. And so there's a lot of things I didn't brief doing this stuff. Anybody ever did a pro se or pro per or whatever in the pro in persona in the United States District Court to try to get through their morass. Well, then now let's go back to the state taxes they say I owe. I present to them that in regards to the state of California assessments were never finalized. They never made any assessment. They're only proposed assessment. Proposed assessments become final under California law and under this section of the Revenue and Taxation Code.